All right, welcome back, and let's continue the discussion now on the judgment of the Court of Appeal on Justice Ngajiwa. I'm now being joined by GT Ogunye, who is a lawyer. Mr. GT, thank you very much for coming on the program.
My pleasure. Thanks for inviting me.
You have seen the judgment. You have read it. I mean, I have seen it as well. You look at the entire judgment. Basically, all the justices of the Court of Appeal would appear to have taken the same position, you know, that the EFCC, so to speak, hasn't got the powers to prosecute without getting some form of clearance, so to speak, from the NJC. That you know, the EFCC should have waited for the NJC to have probably conclude its own work before going ahead. At least take action on the judge in question before going ahead to prosecute.
Yes, I've read the judgment. I read the judgment 5 times. And it's a unanimous judgment,
yes,
by the learned justices of the Court of Appeal who decided that appeal. Justice Abimbola Osaruge, Obaseki Adejumo, yeah. Justice Mohammed Lawal Garba, and Justice Nempa, who decided the appeal. It was a unanimous decision. But the more I read that judgment, the more I came away with the impression and conclusion that that judgment ought not to have been decided like that. I saw a reactive judgment. I saw a judgment that one can call a judicial response to some of the development that are taking place in the justice sector, justice administration sector recently, especially the arrest.
Like the judiciary fighting back.
Especially the arrest of the judges. I saw a protectionist judgment that tried to erect a solid, impenetrable wall of defense against serving judicial officers, so that the nation, our country, will not be treated to the spectacle of having serving judicial officers being tried in a court of law. That's what I saw. My view is that the judex, a judge sitting alone, or a panel of judges determining any question of law, ought not to engage in legislative judgment or a judgment that will create the law. The duty of the court is to interpret the law, to say what the law says, not to declare what the law ought to be. And so
it appears to you that's what this
yes, because all the provisions of the Constitution that were cited,
because it's cited quite a lot.
There is no one that specifically states that before any of the anti-corruption agencies could try a serving judge, there must be a kind of clearance from the NJC, or that the NJC, as a condition precedent, first must have tried that judge for misconduct under the provisions of the Constitution. There is none. And what are these sections? Section 153 of the Constitution establishes a number of bodies that are called executive bodies, including the National Judicial Council. And I will dilate on that. The Independent National Electoral Commission, the Federal Judicial Service Commission, the Code of Conduct Bureau, and one or two other bodies like that, the Federal Character Commission. These bodies, and Federal Civil Service Commission, these bodies are called executive bodies. The question is, why are they called executive bodies? They are called executive bodies because, and in particular the NJC, regardless of the fact that the word judicial is used. is an administrative body. It doesn't carry out judicial function. A judicial function is a function of a court sitting as a court, an arm of the judiciary. So the NJC carried out administrative functions, including the issue of recommending suitably qualified candidates for employment to the appropriate authority, and then recommending disciplinary action to be taken against them. So the NJC does not even directly discipline a judge. It recommends disciplinary action to be taken to the executive, to the president of the country, in relation to the head of courts at the federal level, to the governor of a state in relation to the head of courts at the state level, subject to the confirmation or ratification of the Senate or the House of Assembly, as the case may be. For the other category of judges, to just the head of the country, the president, or the governor, as the case may be. So without the concurring position of the National Assembly, of the Senate and the House of Assembly. So that's what it does. So even the task of discipline is carried out in conjunction with the executive. So it is clear that if you look at those section 153, section 158, that guarantees the independence of action of these bodies, that provides that in the discharge of their responsibility and their duties, they shall be independent, meaning that there shall be no interference in how they conduct their act. For example, INEC is expected to be independent, so they shall not be teleguided in the how they, so that's what that section speaks to, section 158. It is not a section that can be latched onto to argue or declare in a court of law that once the NJC does not carry out its functions in relation to an allegation of misconduct being leveled against a serving judge, then the anti-corruption agencies cannot perform their functions.
If INEC, for instance, does not punish a resident electoral commissioner accused of...
I can give you a clear example. I can give you a clear example. Only recently, some INEC officials were arraigned before a court of law. The question then was not whether they had first been disciplined by INEC. As at the time they were being arraigned, many of them were still in the employment of INEC. Yes. And that's what is expected. As a matter of fact, the public service rules, federal public service rule and the state public service rule, as the case may be, has a provision relating to what is called interdiction. And people forget, judges are also part of the public service of the Federation, although you have a judicial service in the Federation. And the process of interdiction simply means that if a public servant, a civil servant, is accused of committing a crime and is taken to a court of law for prosecution, he is immediately suspended and is placed on half salary. At the end of the day, if he is found not guilty, he then writes to the Federal Civil Service Commission or the State Civil Service Commission to inform that I have been cleared, I want to resume. And then he will be paid the backlog. That's what is expected. So once an anti-corruption agency finds good reason to arrest a judge, investigate a judge, and arraign a judge, what the NJC is expected to do is to suspend that judge.
Pending the outcome.
Pending the outcome. As a matter of fact, it used to be the argument of judges that were tried by the NJC earlier, including the case of Justice Sokpene, you know, one of the judges that were dealt with earlier, that, if the allegation against me is bribery, you are not a court of law. You are an administrative body, NJC.
That is true.
So you cannot try me if the same set of facts you are relying on, the same set of facts that could have granted a criminal allegation, unless the court tries me first. That used to be the allegation. And then the NJC will say, no, regardless of that, you know, we can do our own job here, maybe tried later. But now, the argument has been reversed. And so what we're being told now is that unless the NJC, you know, finds a judge guilty first, in respect of misconduct,
that's quite absurd,
and remove him from office, stripped of his judgeship, then the court of law cannot proceed. And this has a lot of implications for constitutional law and administrative law and our democracy. The argument used to be that there is an attempt to usurp the powers of the court, to usurp the power of the judiciary. What we are currently witnessing, what this judgment exemplifies, is that the Court of Appeal arrogates to the NJC the power that it doesn't have, and does attempt to usurp the powers of the executive. And why do I say this? Under the Constitution, all federal matters, federal actions are instituted in the name of the Attorney General, or deemed to be instituted by the Attorney General. And so that's why the title of this case is Justice Nganjiwa versus Federal Republic of Nigeria. So EFCC does not institute an action or file a charge or information in its name. That's why it is an information. It's deemed to have been filed by the Attorney General. Now, the power of the Attorney General given to the Attorney General by the Constitution is under Section 174 of the Constitution. Power over public prosecutions. And there are no restrictions. Is the master of it. Once an investigation is conducted and a prima facie case is found against any person, save those who have immunity under Section 308. And we're talking about those four offices, President, Vice President, Governor and Deputy Governor. Except in respect of those offices, the Attorney General could file. And so what this decision seems to have decided now is that, and this is very interesting, is to then grant temporary immunity to judicial officers. The decision, my lords, in that judgment, declare, and they did that so repetitively, that, oh, what we're trying to do is not to grant immunity to judicial officers against criminal prosecution. They can be prosecuted. What we are saying is that unless and until the NJC sits over the allegation of misconduct, that immunity, that temporary immunity. Why? Because the immunity that is even granted under Section 308 is also temporary immunity. It relates only to the time the person is in office. So if somebody is in a judicial office, and you say that it cannot be proceeded against unless and until the NJC, you know, deals with the allegation of misconduct, then you are granted immunity. Just in the same way, the Constitution provides in Section 143 and Section 188 for impeachment proceedings. So if you don't impeach a governor, or a deputy governor, or a president or vice president, who enjoys immunity, you may not be able to drag him before a court of law. So, and the Constitution specifically so provides. But this decision, without such provision under Section 153, is now saying that unless and until there is a proceedings to remove the judge from office, which is also like impeaching a judge, you cannot do anything. That is not what the Constitution provides. And that's why, you know, I've read the judgment. That's why I have no doubt in my mind that it is a judgment that the court ought not to have delivered. I read the judgment. I could see fear. I could see phobia. I could see protectionism. I could see the judges saying, why should they come and attack us without going through the NJC? Such words were used,
Are you surprised that it's actually happening? Because before now, some people had actually expressed, that doubt that the judiciary would be able to deal with the cases of some of these judges. That, asking a judge to appear before another judge is like putting the judge himself who is trying the case on trial as well.
No. The maxim is that let justice be done even though the heavens fall. The office of a judge is an office of courage. It's an office of responsibility. It's not an office of fear. It's not an office of, kowtowing to sentiment. Justice has to be done even though the heavens fall. And so, look, if the fear is that judges are not expected to try fellow judges who are still serving, the question is, if they are policemen who are armed robbers, should they be investigated by fellow policemen and be charged to court? That's the question. So we can throw up these scenarios all over the place and nothing gets done. Okay? So the idea that, the dignity of a judge will be destroyed, or that the reputation of the judiciary will be undermined if you see serving judges being tried, I can't get it.
Let me quickly ask you this. What exactly is the implication of this case now, this judgment now, on the cases of the other judges in court?
The implication is clear. By the principle of precedent and stare decisis, by which a higher court's decision is binding on any question that may be raised in the lower court on the same point. All the cases involving the judges,
have to be thrown out.
The verdict is clear. The verdict is clear. So, so that's why I say I see a kind of fight back. I see a kind of backlash. I see a kind of, okay, we are the courts. So you want to embarrass us, we'll tell you what the law is. And what the courts say the law is at every point in time is the law. So it's very interesting. And I've seen lawyers argue that, this is the right thing to do, how can you be trying a judge, remove him first. That's what is right. I know what is right. But I care more about that which is right, that has been codified. That which is right, that has been stated in the law. Judges are not knight errants, fishing for what the law ought to be. They are learned men and women who declare what the law is at every point in time. And my submission here this evening is that the Constitution has not provided that as a condition precedent to trying a judge, as a condition precedent to the executive branch of government exercising its powers, including enforcing the criminal law in the land under Section 5 of the Constitution. Because, people talk about separation of powers. As lawyers, we often talk about, don't usurp the powers of the court. And many of us who got qualified during the military era is something that we're very touchy about. Because during that era, there was no rule of law. Rule of law had been suspended. The courts and their jurisdiction have been shackled by the gyves of draconian decrees. Ouster decrees.
Mr. Agunya, thank you very much for coming to the program. Thank you very much. All right, we'll take a short break, and when we come back, we'll wrap things up. On DEJI360, we don't just ask the questions. What is wrong with amending the Constitution the way the National Assembly members have been doing it? We seek answers.
The Constitution is constituent. Our problem is not lack of laws. Our problem is lack of the willpower to implement our laws.
Answers that provide clarity.
While we negotiate, we should try to make it a point that the girls must be complete.
The clarity you need to make informed judgment so that you can make the right decision and take action. people are saying it is you politicians that are responsible for this, that you are the reason why this is happening.
All these dollars that call themselves governors in this country?
I wish we had people like Tony at the National Assembly.
God forbid that I go to join that band.
DEJI360, providing clarity to issues.